Welcome back, everyone. Get ready to dive deep into something that's everywhere but often misunderstood in the world of data protection: legitimate interest under GDPR.
Ah, yes. Legitimate interest. It's one of those things that sounds simple enough on the surface, but gets really complex really quickly in practice.
Right, it's not just about what's convenient for companies, even if they say it's for a good cause. So we're going straight to the source for this deep dive, the EDPB's brand new Guidelines 1/2024.
Fresh off the press, these guidelines are all about clearing up the confusion and setting the record straight on how legitimate interest should and shouldn't be used.
And to help us unpack all of this, I've got an expert in GDPR by my side, ready to demystify legitimate interest.
Absolutely, let's do it.
All right, let's jump right in. We've all seen it. Article 6 of the GDPR, that's the bit companies sometimes rely on to process data, saying it's necessary for their legitimate interests. But what does that actually mean, and how often is it misused?
You hit the nail on the head. Legitimate interests. Can sound pretty vague, can't it? And yeah, you're right. Companies have definitely tried to use it as this catch-all excuse to just process data however they please. But these new EDPB guidelines, they're here to say, nope, not so fast. They make it crystal clear. Article 6.1f is not a get-out-of-jail-free card.
So no more hiding behind some vague claim of legitimate interest.
That's the idea. The EDPB is really cracking down on that kind of loosey-goosey interpretation. They're making it crystal clear that Article 6.1f should not be a company's automatic go-to, not the default setting for data processing. And it's definitely not meant to be some kind of last resort when other bases don't work out.
Yeah.
It's on equal footing with all the other legal grounds for processing data, which means it deserves just as much scrutiny.
Makes sense. But how do we figure out if an interest is truly legitimate in the eyes of the GDPR? Where do we even begin?
Well, it's not just about what a company wants to do with your data, right? There's a specific three-part test laid out in these guidelines. And get this, all three conditions have to be met, not just one or two, all three.
Okay, a three-part test. I'm intrigued. Break it down for us.
So, first and foremost, the interest itself actually has to be legitimate. Sounds kind of obvious, right? But the EDPB is setting a high bar here. This can't be some fuzzy business aim or just something that would be nice to have. The guidelines are very clear. The interest has to be clearly defined, it has to be grounded in law, meaning it doesn't go against any other laws already in place, and it has to be relevant now, in the present, not some hypothetical future need.
So no more, well, we might need your data for this someday, so we'll just hang on to it just in case.
Nope, not if companies are playing by the GDPR's rules. These guidelines are all about being specific. And they even give a really interesting example to make this point.
Ooh, I love a good example. Lay it on us. What is it?
Remember that case with the Neighborhood Watch Group? They wanted to put up all these cameras for crime prevention, claiming it was for the greater good and all.
Sounds a little bit like they were overstepping, maybe, even if their intentions were good.
Right, and that's exactly what the EDPB said. They called the group out for their reasoning being way too vague. Basically, to even start figuring out if an interest is legitimate, it needs to be way more specific.
Yeah, that makes sense. Okay, so that's the first hurdle. What's the second condition for legitimate interest to fly?
Necessity. And I don't just mean, oh, it would be kind of convenient to have this data. We're talking truly necessary for achieving that legitimate interest.
That's a pretty high bar. It seems like that's something a lot of companies might misinterpret, assuming that any potential benefit is enough to justify collecting and using data.
You're right, it can be tempting to think that way. But remember, the GDPR is about protecting individuals. And that means companies can't just go around hoovering up data just in case they need it. The guidelines are very clear. If there's a less intrusive way to achieve the same goal, something that respects your privacy more, then the company has to choose that path.
So it's almost like this ties directly into that principle of data minimization that we hear so much about with GDPR.
100%. Data minimization is key here. It's all about collecting and processing the absolute bare minimum amount of personal data needed, nothing more, nothing less. And it has to be directly related to that specific legitimate interest. No fishing expeditions allowed.
2 down, 1 to go. What's the final test companies need to pass?
This is the big one, arguably the most important and the most tricky, the balancing act. It basically means that a company's interests, even if they are legitimate and necessary, they cannot outweigh your fundamental rights and freedoms as an individual.
Okay, now, this is where things start to get really interesting. How do you even begin to balance those competing interests in a practical way? I mean, where do you even start? I'm really interested to hear how the guidelines address this whole balancing act.
Oh, you and me both. And thankfully, the guidelines go into a fair bit of detail on this, which I'm ready to break down for you. It's all about finding that sweet spot, where data processing can happen without stepping on individual rights.
Right, finding that balance. All right, let's unpack this whole balancing act thing, because it sounds like it could get pretty complicated pretty quickly.
Yeah, it's definitely more nuanced than some companies might want to admit. Thankfully, the guidelines actually lay out a pretty clear framework to follow when it comes to weighing those competing interests.
Okay, good. A framework is good. So walk us through it. What are we actually balancing here?
So on one side of the scale, you have those core rights and freedoms that the GDPR is designed to protect. We're talking about things like privacy, obviously, but it goes even further. Freedom of expression, the right to non-discrimination, essential rights that need to be safeguarded no matter what.
Right, because those are non-negotiable, but then on the other side, you have these other interests. What exactly are those?
Good point. It's not just about those fundamental rights,
Yeah.
right? The GDPR also recognizes that individuals have other interests that need to be factored in. Things like their financial well-being, their social standing, their reputation. Even things like personal preferences come into play here.
So it's about the big picture impact on a person's life, not just preventing direct harm. It's about making sure companies aren't cutting corners, even if it's technically legal, and actually respecting their users.
Exactly. You've hit the nail on the head. It's about making sure the scales aren't unfairly tipped in the company's favor just because they say legitimate interest. And that's where these new guidelines are so important. They're really driving home the message that Article 6(1)(f) cannot, I repeat, cannot be used as a sneaky way to sidestep a company's core GDPR obligations.
It's like, yeah, legitimate interests exist as an option, but don't even think about using it as an excuse to avoid getting proper consent if that's what the situation requires.
Exactly. The balancing act is there for a reason. So when it comes to actually doing that balancing, one of the key things the guidelines look at is, what's the potential harm to the individual? How bad could this go for them?
Okay, harm assessment. Makes sense. So how do we actually measure that? What are the factors that get taken into account?
Well, first and foremost, they look at the data itself. How sensitive is this information we're talking about? Because we're talking about a spectrum here, right? Are we dealing with something like your medical records highly sensitive, or are we talking about something much more trivial, like your favorite brand of coffee? The potential impact on your rights and freedoms is clearly very different depending on what data we're talking about.
Makes sense. Some data is inherently a much bigger deal than others and therefore needs that higher level of protection. What else?
The context of the data processing matters a lot too. The guidelines are very clear that you have to look at who the data controller is, what their relationship is with the person, and most importantly, what they're actually doing with the data. What's the purpose of all this processing?
Right, because it's all connected, isn't it? You have to look at the potential consequences for the individual if things were to go wrong.
Precisely. For example, could this processing lead to discrimination? Could it cause financial harm? Could it damage someone's reputation? These are all serious things to consider. And speaking of vulnerable groups, remember how we talked about children's data needing special protection under the GDPR?
Of course, because kids need that extra layer of protection, especially online.
Absolutely. And the guidelines are very strong on this point. They basically say that if a company wants to use legitimate interest to process children's data, the bar is set incredibly high. They really have to prove their case, and the best interests of the child are paramount.
Okay, that's good to hear. So it sounds like the guidelines are really making companies think twice about the potential consequences of their actions, which is what we want, right? They've considered the data itself, they've looked at the context, potential harm. What's next in this balancing act?
This is where things get really interesting. The guidelines introduce this idea of reasonable expectations.
Reasonable expectations. Okay, now you've got my attention. Tell me more about that.
So it's kind of like putting yourself in the shoes of that person whose data is being used. It's not just about what's legal, it's about what's fair and what's ethically sound. So the guidelines are essentially asking, given the relationship between this individual and this company, the type of service being provided, the whole context, would a reasonable person actually expect their data to be used in this specific way?
Oh, I like that. So it's less about a purely legalistic interpretation and more about common sense, almost a human-centered approach.
Exactly. It's about what people would reasonably expect. And to illustrate this, the guidelines even highlight a really interesting case involving, you guessed it, social media.
Oh, here we go. Social media and data privacy, always a recipe for a good debate. What happened?
So basically, this case found that even if a social network is free, you're not paying to use it. users still don't necessarily expect their data to be used for targeted advertising without their consent. Just because a service is free doesn't mean it's a free-for-all when it comes to their data.
That makes sense. It's all about setting clear expectations from the beginning.
Okay, so let's say we've gone through all these steps. We've assessed the potential harm, we've thought about reasonable expectations, and it's looking like the scales are tipping in favor of the individual, of their right to privacy. Is it game over for the company? Or is there anything they can do to tip the balance back in their favor a bit?
That's where mitigating measures come in. And this is where I think we see the flexibility of the GDPR shining through.
Mitigating measures, so like bonus privacy points for good behavior.
Kind of. It's basically about going above and beyond the bare minimum that the GDPR requires and implementing some extra safeguards to protect people's data.
Okay, give me some examples. What kind of things are we talking about here?
It could be something as simple as, say, giving people the option to delete their data, even if the company isn't legally required to do that. Or it could be about giving users more control over how their data is used, like more detailed options for opting out, that kind of thing. So it's about transparency and control, really empowering individuals when it comes to their own data.
Exactly. It shows a real commitment to data protection that goes beyond just checking boxes for compliance. And that counts for a lot.
This has been super interesting. We've covered a lot of ground on this whole balancing act thing, but there's one area in particular where I think this gets extra tricky. Ready to tackle it?
Hit me with it. I'm ready for the challenge.
Let's talk about direct marketing. It's everywhere these days, and I have a feeling legitimate interest gets thrown around a lot and maybe not always in the right way.
You are not wrong. Direct marketing is a whole other can of worms when it comes to legitimate interests, and thankfully, the new guidelines actually offer some much-needed clarification on this.
Oh, good, because this is something I think a lot of people can relate to, the constant barrage of ads and marketing emails. So how does this all fit with GDPR?
Well, you've got this constant tension, right, between a company's desire to reach consumers and people's right to privacy. And GDPR, along with the e-privacy directive, tries to strike that balance as best as it can.
Okay, so two sets of rules, potentially at odds with each other. That sounds potentially complicated for companies to navigate.
Right, it adds a whole extra layer, for sure. So we know that Recital 47 of the GDPR suggests that processing for direct marketing may be considered a legitimate interest, but, and this is a big but, the guidelines are very clear that this is not some kind of automatic green light for companies.
Well, there's always a catch, isn't there? So just because it could be considered legitimate in some cases doesn't mean it always is.
Exactly. You still have to go through that entire three-part test we talked about. Is it a legitimate interest? Is the processing necessary? And, most importantly, does it pass that balancing act? Because remember, even if the company has a legitimate interest, it can't outweigh the individual's fundamental rights and freedoms.
Right. We can't forget about those. But then on top of all of that, you've got the e-privacy directive coming into play here. So how does that change things?
Well, generally speaking, the e-privacy directive often requires an even higher bar when it comes to direct marketing. This is especially true for electronic communication, things like email, text messages, where in most cases you really do need explicit consent to contact people.
So does that mean legitimate interest is basically a non-starter for things like marketing emails?
It's not quite as clear-cut as that. There's one important exception that we should mention, tucked away in Article 13.2 of the e-privacy directive.
Okay, there's always an exception. I should have known. What does it say?
So this exception allows companies to send you marketing about their own similar products or services. And they can do this even without your consent, but only if you're already a customer.
So there's some wiggle room when it comes to existing customer relationships. But what are the conditions there?
Two big ones. Number one, they have to have told you very clearly, like, no small print that you might get these marketing messages when you first gave them your contact info. Transparency is key.
Right, so no sneaking people onto a marketing list without them knowing what they're getting into.
Exactly. And the second condition is that you, as the customer, have to have a super easy way to opt out at any time. It's all about putting the control back in your hands.
So it sounds like, in a nutshell, direct marketing and legitimate interest. It's complicated, there are exceptions, there are nuances. It's definitely an area where getting some solid legal advice is never a bad idea.
100% agree. It's a balancing act, and it's one that a lot of companies are still trying to figure out. Thankfully, with these new guidelines, we're all getting a bit more clarity, which is a win for everyone.
It absolutely is. This has been a fascinating deep dive into the world of legitimate interest. We've learned it's not just some abstract legal concept.
Yeah.
It has a real impact on how companies can use our data.
It really does. And if I can leave your listeners with one final thought, it's this. If a company has to jump through a million hoops and bend over backwards to justify using your data without your consent, maybe, just maybe, they need to rethink their whole approach. Because at the end of the day, transparency and respect for individuals, that's what really matters.
Perfectly said. A huge thank you to our expert for guiding us through this complex topic. And for our listeners, if you're eager to learn even more, be sure to check out the resources we've linked in the show notes. Until next time, stay curious about your data.